Good day, Crime Talk aficionados. We have another great show for you today. First, the media is asking to vacate the gag order in the Bryan Kohberger case. And there's a question kind of stewing around. Is Bill Thompson opposed to the death penalty? Raul Valle was found not guilty by a jury yesterday. It wasn't Travis Decker. And apparently it is not safe to take your kids anywhere these days. Sarah Boone. Remember her? The lady who stuffed her boyfriend into a suitcase to die? She's back, and she's proving why she is one of the most unlikable people in the world. We have This Day in Legal History, and our legal quote of the day is in honor of Sarah Boone. And then our dumb criminal from from just down the street from the Crime Talk studios. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Listen, if you want to support the channel, the best way to do it doesn't cost you a dime. Just hit that subscribe and like button. All right, before we get to the docket, let me remind you, go to crimetalksearch.com and sign up for that background subscription service today. Now, you may think, why do I need a background subscription service? Well, if somebody is coming into your life, or maybe somebody's there and maybe you just don't feel like you trust them much anymore, maybe there's something going on weird, do a background search on them. See what's going on. You can find out, maybe they're married. Maybe they have a whole new bunch of social media presence that they didn't tell you about. Maybe they have a bunch of emails that they need for that new social media presence that they didn't tell you about. For all the Tinder pages and all the other dating apps that are out there. Go check it out, because when you have that background subscription service, that report is going to be emailed to you, and you're going to find out phone numbers, email addresses, social media presence, whether they're married, divorced, whether they have a criminal history, and whether they're on a sex offender registry, plus a lot more. Go to crimetalksearch.com. You're going to be happy that you did. All right, ladies and gentlemen, let's go ahead and get to the docket. It is Thursday, July 10th, my birthday. Thank you. And so let's get to it. First, a media coalition has filed motions to vacate the gag order in the Bryan Kohberger case. So, a coalition of 24 media organizations has formally petitioned the District Court of the 4th Judicial District in Ada County, Idaho, to vacate the non-dissemination order, commonly known as the gag order. This is in the case against Bryan Kohberger, who pled guilty on July 2nd to the murders of the University of Idaho students and one count of burglary. Now, the motion, which was filed on July 3rd but just made public the other day, seeks to lift the restrictions that prohibit attorneys, law enforcement, and other involved parties from making extrajudicial statements about the case beyond quoting official court documents. Now, the motion was submitted by a broad coalition of national and local media entities, collectively referred to as the Media Coalition. Now, the attorneys, Jay Olson and Corey Karen and Anders Peterson of the law firm of Stoll Rives, the group includes prominent outlets such as the American Broadcasting Companies, ABC, the Associated Press, CBS, CNN, Fox News, NBC, the New York Times Company, and News Nation. Now, the regional and specialized organizations are also part of the coalition that include the Bonner County Daily Bee, Cowles Publishing, the Spokesperson's Review, the Coeur d'Alene Press, East Idaho News, Idaho Press Club, the Ion Media Networks, the Lewiston Tribune, the Moscow Pullman Daily News, Scripps Media, and the Society of Professional Journalists, States Newsrooms, as well as the McClatchy Company. You could have included Crime Talk, but they didn't ask. But I would have chipped in to make that available to the public as well. Anyway, now this same coalition had previously intervened in the case of Bryan Kohberger on issues related to media access, and the gag order demonstrated their ongoing interest in ensuring public transparency. Now, the filing is supported by declarations from Rebecca Boone, a reporter from the Associated Press, and attorney Wendy Olson, which emphasizes the order's impact on journalistic practices and the First Amendment rights. Now, the coalition has requested requested an opportunity to present oral argument at the court's earliest convenience. Now, the primary impetus for the motion stems from Kohberger's guilty plea on July 2nd, which fundamentally altered the case's trajectory, obviously, because there won't be a trial. That's where Kohberger obviously admitted to the November 13th, 2022 stabbing deaths of Madison Mogen, Kaylee Gonzalez, Xana Kernodle, and Ethan Chapin at their off-campus residence there in Moscow, Idaho. Now, under the plea agreement, he waived his right to an appeal, agreed to consecutive life sentences without parole, and the minimum punishment, and consented to forego a pre-sentence investigation. And that sentencing is set for July 23rd before Judge Hippler. Now, the non-dissemination order initially imposed on January 3rd of 2023 and revised twice thereafter, which the current version dated is June 23rd, 2023, was designed solely to preserve Kohberger's Sixth Amendment right to a fair trial by mitigating prejudicial publicity. However, no trial is forthcoming, and no jury to be impaneled for guilt or sentencing determinations. The coalition argues that the order's continuation is unwarranted. At the change of plea hearing, the prosecutors requested the order remain in effect until sentencing for preparatory conveniences, a rationale the coalition deems insufficient to justify ongoing restrictions of free speech. The motion asserts that vacating the order would restore the media's ability to gather information from key sources, thereby serving the public interest in transparency regarding this high-profile case. Couldn't agree more. Now, the coalition's legal argument centers on the contention that the non-dissemination order now constitutes an impermissible prior restraint of free speech under the First Amendment, and its original justification, the protection of the fair trial, is now moot. The motion emphasizes that any restriction on speech must serve as a legitimate governmental purpose that outweighs the First Amendment infringements. And here, the order is deemed vague, overbroad, and unduly restrictive, failing to meet the narrowly tailored requirements by the constitutional standards in which the judge is supposed to do that. Anyway, the memorandum supporting the motion highlights that Kohberger's plea eliminates any risk of jury prejudice, rendering the order's effects more than collateral on media rights. And to underscore the media's role as a public surrogate, arguing that prohibiting comments from involved parties hinders ethical journalism practices, such as seeking diverse perspectives for balanced reporting. Furthermore, no alternative justification, such as the state's convenience in sentencing preparation, suffices under the established authority, like the case of Nebraska Press Association v. Stewart, which limits gag orders to fair trial protections. And as of July 10th, the motion remains pending with no ruling from the court. If the motion is granted, it could enable greater disclosure of case details, potentially through public statements and records, enhancing accountability in the widely followed proceedings. I could not agree more with this. There is no further basis for this non-dissemination or gag order. That went away when Bryan Kohberger pled guilty. There's never going to be a trial. There's never going to be a jury to impanel. So what is the reason for that? And I thought the prosecutor's excuse of, well, let's just keep it in place for another couple of weeks. Now, what could the judge do? He could say, you know what, let's have a hearing on this issue right after the sentencing hearing for Bryan Kohberger. That's what he could do. Or he could say, you're right, I'm going to go ahead and lift it. Because what does it matter at this point? We know what the sentence is going to be. It's simply a perfunctory administrative process at this particular point. The judgment of conviction has entered. The only thing is the formality of the sentencing. Next, another issue that's come up is the prosecutor, Bill Thompson. Is he maybe opposed to the death penalty? Well, let's talk about it. So in a development that has elicited significant public and familial backlash, the Latah County prosecutor, Bill Thompson, facilitated a plea agreement, obviously in the Bryan Kohberger case, which resulted in a guilty plea. Now, this agreement, which spares Kohberger the death penalty in exchange for this guilty plea and life in prison without the possibility of parole, has drawn scrutiny of Thompson's prosecutorial record over his 33-year tenure. Now, Thompson, who is a Democrat, has served as the Lake County prosecutor since 1992 and is the longest serving in Idaho, following 8 re-elections. And he displayed obviously some visible emotions during the hearing, including tears while recounting the factual basis and the timeline of the crimes and naming the victims. Now, Thompson had signaled to the Moscow, Idaho community, still reeling from the tragedy, that he intended to pursue the capital punishment against Kohberger, obviously the student. However, the plea deal aligns with a pattern in Thompson's career, where he has consistently opted for negotiated resolutions rather than seeking the death sentence. Now, an analysis underscores this trend, revealing that Thompson has never successfully maintained a death penalty outcome for any convicted individual during his time in office. Now, this history includes several notable cases where the death penalty was explicitly removed from consideration through plea agreements. So, to contextualize the Kohberger plea, it's essential to review prior instances in which Thompson elected not to pursue capital punishment. Now, these cases provide some insight into whether his decisions stem from a general disfavor toward the death penalty or from apprehension about proceeding to trial. So first, we got the case of Dale Shackelford. This case goes back to 2000. So Thompson secured a death sentence for Shackelford, convicted of murdering his ex-girlfriend and her boyfriend before burning their bodies. This remains the sole instant in Thompson's career where the death penalty was initially imposed. However, the Idaho Supreme Court later revoked the sentence, and Thompson chose not to advocate for its reinstatement, allowing Shackelford to receive a life term instead of death. Then we got the Silas Parks case. Now, Parks, and this case goes back to 2014, Parks pled guilty to voluntary manslaughter after strangling his pregnant wife, and Thompson did not seek the death penalty, citing insufficient evidence to prove premeditation, obviously a key aggravating factor required for capital charges in Idaho. Now, Park was sentenced to a maximum of 40 years in prison. Then we got the case of John Lee, which took place in 2015. Now, in a mass murder case involving the deaths of 3 individuals, including Lee's adoptive mother, Thompson negotiated a plea that allowed Lee to admit guilt in exchange for eliminating the death penalty as an option. Now, this resolution mirrored the outcome in Kohberger's case, prioritizing a guaranteed conviction over a capital trial. Now, the precedent suggests a pragmatic prosecutor strategy rather than an ideological opposition to the death penalty or a fear of trial proceedings. In the Parks case, for instance, the decision was explicitly tied to evidentiary limitations, indicating a calculated assessment on the case strength or weaknesses. Broader factors influence such pleas in death-eligible cases, as noted in several analyses, including the substantial financial burden of capital trials and appeals, which could take 20 to 30 years. Obviously evident in the Kohberger matter, where the cost had already exceeded $3.6 million by April of 2024, prompting Thompson to request an 800% budget increase for trial. As my old boss used to say, there's always money for justice. Anyway, the risk of hung juries, mistrials, or prolonged appeals in death penalty pursuits can lead to uncertain outcomes, even with strong evidence such as cell phone geolocation data, surveillance footage, eyewitness testimony, and even DNA matches, which were present, obviously, in Kohberger's prosecution. Obviously, there's some divided opinions regarding whether the plea was fiscally motivated to avoid further expenses. Others perceive it as a leveraging the death penalty to ensure Kohberger's permanent incarceration without the risk of trial. So there's no substantial evidence indicating Thompson is scared to go to trial. Rather, his consistent pattern appears driven by a preference for efficiency, assured resolutions that minimize resource strain and spare victims' family the emotional toll of protracted litigation. So as Thompson approaches retirement, I guess one could potentially suggest that he prioritizes closure over long capital cases that will be drawn out. Now, during the July 2nd hearing, Thompson outlined the sequence of events, and Kohberger allegedly entered the student's residence at the 1122 King Road through a side door, fatally stabbing Mogan and Gonsalves on the 3rd floor, then Kernodle and as she descended the stairs, and finally Chapin in the bedroom using the K-bar knife. Now, Kohberger remained impassive, responding affirmatively when questioned about his guilt, and understood of the no parole terms. Now, obviously, victims' relatives, including the Gonzalez family, expressed outrage, claiming that the state failed them by not consulting all parties adequately and rushing the process with only 1 day's notice. They lamented the loss of a full trial to confront the details of the crime. Conversely, the Chapin and Mogan families supported the deal, citing relief from the ongoing court obligations and the desire to focus on healing. Kohberger's sentencing is July 23rd. So at the end of the day, it just doesn't matter. Listen, I've only done one death penalty case that was going to go death, and then we got him to change their mind and not go death. So I don't want to say I've got, all the answers on death penalty cases. It's a complicated area of law for sure. A lot of mitigation work, a lot of negotiations that go on to try to do that. But as I said early on in these cases, the goal of any death penalty attorney is take death off the table. That is the win. Okay. Prosecutors don't take cases death unless they think that their evidence is overwhelming. But even as we saw on a jury verdict the other day down in Florida, where it doesn't have to be unanimous, 10-2. Okay, they only needed 8 for the recommendation there. Idaho, it's got to be unanimous. One juror says no to death. You're right back where you started from. I think the prosecutor made a good call. And don't get me wrong, if somebody kills 4 people and that's not worthy of the death penalty, I'm not exactly sure what is then. But I understand the prosecutor's rationale. And I know the family's upset now, but listen, to know that there'll never be an appeal, no reversal, no post-conviction hearings that drag on for years, that finality will eventually come to them, and they will realize that the correct decision was made. Next, a jury finds Raul Valle not guilty. So, back in March of 2022, a fight occurred at a house party in Shelton, Connecticut, involving approximately 25 teenagers. Raul Valle, then 16 years old and a student at the St. Joseph High School in Trumbull, was alleged to have brandished a switchblade-style knife and instigated the altercation. And during the incident, Valle stabbed James McGrath, a 17-year-old lacrosse player at Fairfield College Preparatory School, once in the heart, resulting in McGrath's death. Now, Valle also stabbed 3 other individuals, Ryan Hines 3 times, including a puncture to the lung, Thomas Connery 4 times in the leg, and Faison Teal once in the arm. The 3 injured individuals were transported to the hospital. Valle was subsequently charged with murder in McGrath's deaths and assault for the injuries to Hines, Teal, and Connery. Now, during the 3-week trial in the Superior Court in Milford, Connecticut, witnesses reported to police that Valle had displayed the knife prior to the fight and initiated the conflict. Prosecutors presented evidence that Valle stabbed McGrath in the heart, Hines 3 times with a lung puncture, Connery 4 times in the leg, and Teal once in the arm. Valle testified that he received the knife from a friend, felt overwhelmed during the skirmish, swung the blade in multiple directions without intent to kill, and experienced a brief blackout. Valle's defense argued that the actions constituted self-defense. Well, following 2 days of deliberation, the jury delivered a partial verdict acquitting Valle of murder, intentional manslaughter, first-degree reckless assault, and second-degree reckless assault. The jury remained deadlocked on the charges of reckless first-degree manslaughter in McGrath's deaths, 2 counts of reckless first-degree assault, and 1 count of second-degree reckless assault related to the other stabbings, resulting in a mistrial on those counts. Now, Valle had previously rejected a plea deal offering 40 years in prison and faced a potential sentence of up to 105 years if he was convicted on all charges. Prosecutors indicated they intend to refile the deadlocked charges. Next on the docket, apparently that wasn't Travis Decker. Good try, though, guys. Anyway, federal authorities in Idaho say they have ended a search in the Sawtooth National Forest after determining it was a case of mistaken identity. The search began Saturday after the United States Marshal Service's Greater Idaho Fugitive Task Force said a family reported they saw a man who looked like Travis Decker, who is wanted, obviously, in the connection and the deaths of his 3 daughters in Washington state. Decker had been wanted since June 2nd when a sheriff's deputy in Washington found his truck and the bodies of his 3 daughters, 9-year-old Peyton Decker, 8-year-old Evelyn Decker, and 5-year-old Olivia Decker at a campground outside Leavenworth, Washington. Now, the discovery came 3 days after he failed to return the girls to their mother's home about 100 miles east of Seattle following a scheduled visit. Now, the family was near a Bear Creek area campsite when they saw this man who was basically the same height and roughly the same weight as Decker, and also had similar hair and beard and tattoos on his arms and calves. Additional tips followed, and federal, state, and local enforcement agencies joined the Marshals Service in their search. They found the man Wednesday afternoon, and U.S. Marshal Service supervisor issued a press release saying that they determined that was not Mr. Decker. Investigators interviewed the cooperative man and confirmed that he was hiking in the Big Creek area this past weekend. So police in Washington on June 10th said they believe they had spotted Decker, a former soldier, near a remote alpine lake in a popular backpacking area in Cascade Range. Tracking teams followed up on a tip from hikers who reported seeing a lone hiker who appeared to be ill-prepared for the condition but had not been found. Now, the Marshal Service has offered up to $20,000 for information leading to the arrest and capture of Mr. Decker. Next on the docket, is anywhere safe for our kids? An 18-year-old Colorado resident, Trenton Moscovita, who will give the presumption of innocence, has been arrested and charged with connection with the sexual assault of a 5-year-old girl at the Pirates Cove Water Park in Englewood, Colorado on July 8th. Now, according to the Englewood Police Department, Moscovita allegedly led the child into a family changing room at the park where he sexually assaulted her. Police state that he covered the victim's mouth to prevent her from screaming, and following the incident, the girl escaped the changing room and informed her parents. A park employee reportedly observing the child as visibly distressed and crying intensely to the extent that she was unable to speak. Now, police detained Moscovita at the scene, and during the arrest, he reportedly attempted to resist officers, asserted that they had apprehended the incorrect individual, and claimed he was at the park accompanying triplet siblings. Security footage, however, reviewed by the investigators, depicted Moscovita entering the changing room with the child and remaining inside for approximately 9 minutes. Moscovita faces charges including suspicion of sexual assault on a child, which carries an indeterminate life sentence here in the state of Colorado, as well as kidnapping, ladies and gentlemen. That's not good, moving somebody from one point to another without their consent. Anyway, he was booked into the Arapahoe County Jail with a $200,000 cash-only bond. He's got court tomorrow, July 11th. Sarah Boone, you remember her? That's right. 7 months post-conviction, the dissatisfied Sarah Boone continuing her incarceration with a flair for frustration, lodging a formal inquiry into her languished appeal because evidently the wheels of justice aren't spinning fast enough for her likings. That's right, Boone earned a life sentence in December of 2024 following a jury verdict of second-degree murder in the demise of her boyfriend, Jorge Torres. Torres was zipped into a suitcase and subjected to a baseball bat's unwelcome attention amid a boozy evening at home. Now, in the lead up to the trial, Boone cycled through no fewer than 8 attorneys over 4 years, each deeming her a challenging client and bowing out accordingly. Her modus operandi, prolific letters to the court decrying perceived inadequacies in legal representation, and on trial's brink, James Owen gallantly volunteered to helm her defense. Now, post-conviction, an appellate attorney was duly assigned, yet progress stalls like a forgotten suitcase in storage. Facing a dismal threat for a lack of brief, Boone dispatched an inquiry brimming with exasperation over her counsel's silence. Her missive details a solitary introduction message from her attorney in February of 2025 via inmate channels, followed by her barrage, 5 messages, 2 handwritten letters, and 9 third-party interventions via email and calls. The appellant's appeal is now in jeopardy, she laments, urging the court to either prod her lawyer into action or furnish her a fresh one. Mercifully, her docket now reflects an extension, pushing the brief's deadline to September 1, affording Boone yet another opportunity to perfect her art of impatience. She's one of the most miserable human beings on the face of the earth. I'm absolutely convinced of that. The record on appeal, that's all that comes in. The appellate attorney doesn't need to talk to that particular individual unless you say, hey, there's a couple of issues. Here's kind of the process. But the only thing that matters is what's on that cold, hard record. That's it. But I guess that's the beautiful thing about being an appellate attorney or post-conviction attorney is, your clients want to talk to you. They wait to see you. They can't wait to see you in jail. But most appellate attorneys don't like talking to their clients because they don't care. Not that they don't care about the client, but they don't need to talk to them because it's only about what's on the record. That's the only thing that's used on appeals, ladies and gentlemen. That's why you got to prepare the record. Anyway, Miss Boone, I guarantee you, I will bet you a huge steak dinner that appeal, any issues that you believe you may have, denied. Just saying. Next, this day in legal history. On July 10th, 1821, the United States formally took possession of Florida from Spain under the Adam-Onis Treaty, addressing issues like runaway slave havens and Seminole raids, strengthening federal control over border crimes. On July 10th, 1890, Wyoming was admitted as the 44th state, adopting a legal system that included progressive laws like women's suffrage, influencing criminal justice reforms. That's right. Wyoming was the first state that allowed women to vote. Our neighbors to the north. Then on July 10th, 1925, the Scopes monkey trial began in Dayton, Tennessee, prosecuting John Scopes for teaching evolution, sparking a national debate on science, religion, and educational law. Remember, it didn't turn out so good for Mr. Scopes, though. And then on July 10th, 1986, congressional committees finalized provisions of the Anti-Drug Abuse Act, passed later that year, introducing mandatory minimums for drug offenses, contributing to the mass incarcerations in the 80s and 90s. One could say those were very intentional, right? So if you had, let's say, a kilo of cocaine, 1,000 grams, you would get the same sentence as the person that had 10 grams of crack cocaine, which is a very small amount, obviously more potent, but people in the black community did crack cocaine more than the people that had the white powder cocaine. And you just throw a little baking soda in there, cook it up, piece of cake, right? Why not maximize your profits? But I digress. Then on July 10th, 2010, the United States completed a spy swap with Russia, deporting 10 Russian agents arrested for espionage in exchange for 4 prisoners, underscoring the legal framework for international espionage. It takes place. And then our quote of the day is in honor of Sarah Boone, the most miserable person in the world. One relevant quote in the area of unreasonable clients comes from the novel A Criminal Defense by William Myers, which captures a common sentiment in the legal community. It is a truism among lawyers that the practice of law would be great were it not for the clients. And criminal defense attorneys complain the loudest of all. After all, our clients are not only needy and demanding, they're also, for the most part, criminals. This observation highlights the challenging posed by clients who may exhibit demanding or unrealistic behaviors, often complicating the attorney's role in providing effective representation. Miss Boone, just saying. And then finally, our dumb criminal of the day. And it comes from literally just down the street here, ladies and gentlemen, down in Broomfield, Colorado, a probably 7-minute drive from my office here. So gather around, ladies and gentlemen, and the CrimeTalk studio audience. Allow me to introduce our dumb criminal of the day, a title bestowed with all the irony it deserves, especially since this escapade unfolds just miles from our doorsteps. Picture this. On a mundane Monday evening, local law enforcement encountered a 49-year-old gentleman lounging in his vehicle at the King Soopers parking lot along Highway 287 and the Miramonte Boulevard. His license plates, a veritable red flag registered as no record. police parlance for canceled, pilfered, or expired in what might charity called extended sabbatical. Approaching with due caution, officers discovered a veritable cornucopia of contraband. Brass knuckles for the extra punch in daily affairs, check. A credit card belonging to someone decidedly not him, naturally. And the piece de resistance over 4 grams of fentanyl artfully concealed, or so he thought, beneath a steak, as if the transformation of groceries into a high-stakes game of hide-and-seek. Needless to say, the Broomfield Police Department triumphantly declared on social media, more fentanyl off the streets. Indeed, this aspiring master of disguise now faces charges including possession of a controlled substance, possession of a dangerous or illegal weapon, and fraud, criminal possession of a financial device, and he's currently reflecting on his choices from the comfort of the Broomfield Detention Center. His identity shielded, saves for a body cam snap of his back at the telltale T-bone. A reminder, viewers, when life hands you a steak, perhaps don't use it as drug camouflage. Stay vigilant and tune in for more tales of the absurd side of crime right here when the action is practically in our backyard. Thanks for watching, everybody. That's all we have for today. Have a wonderful day, and we'll see you tomorrow. And remember, the Constitution matters.